next in number 70-73, Miller against California. Mr. Marks, you may proceed.
Mr. Chief Justice, and may it please the Court, in preface to my argument, which eventually I hope will tie in with the questions which are raised on certiorari, I'm going to make some statements which may sound as if they're pejorative or demeaning. They are not so intended. I express them merely as a statement of what I have experienced in the defense of obscenity cases. My first observation is that it is, as far as I can tell, probably no member of this court has engaged in either the prosecution or the defense of an obscenity case where you are required to deal with the various rules of law and procedure which have been set forth by this court concerning the handling of such a case. Therefore, it's somewhat equivalent, as my wife used to say, you can understand that I have a lot of pain when I have a child, but you'll never experience it. There is a lot of pain in the trial and trying to work out the rules which have been established by this court. The second proposition is that this court has expressed, or perhaps not expressed, but subvocalized the assumption that lower courts and lower judges, both state and federal, will obey the mandates of this court when it comes to deciding an obscenity case. This case is an illustration of the fact that such an assumption is totally false and is an illustration of what, in my opinion, is an immutable proposition that when you're dealing with obscenity or dealing with pornography, that for the most part it is a visceral turnoff to the majority of the courts in which you go in front of. And thus you may, as in this case, present uncontrovertible proof, uncontested proof that the material is protected, uncontroverted proof and irrevocable proof that there has been a prior judicial decision, as it was in this case, uncontested by the state, that the material was constitutionally protected, and that nevertheless the defendant must endure what in this case was a 7-week trial, plus some other various procedural propositions which I will outline. And I think this might also illustrate why this court, I think, was absolutely wrong in Harris v. Younger, or Younger v. Harris and its progeny, in holding that one criminal prosecution is not any type of a hardship upon a defendant, at least in the area of obscenity, because the criminal, and it might also illustrate the fact, and something that I'm going to urge to this court, that there should be an attempt to delineate the difference between an obscenity prosecution and a prosecution under the ordinary rules of criminal procedure, because they do not jive, and for the past 10 or 15 years since Roth, courts have been trying to tear or take the obscenity issues and weave them and enfold them into the area or environment of a criminal trial. And the rules of criminal procedure just do not meet the issues. The suggestion is going to be then, if my analysis is correct, that this court must fashion some procedural rules for the conduct of obscenity cases along the lines of Mapp versus Ohio, because as this court well knows, there has been a total chaos in this area. Now, the first proposition that I have with respect to the rules laid down by this court is that there is an irreconcilable conflict between the decisions of this court. Irreconcilable in the sense that they are logically inconsistent. However, one court pointed out, and I have not been able to find the case, that logic is the minion and not the master of the law, so we can avoid that little proposition that perhaps this court has been logically inconsistent, because it really doesn't matter if we can fashion some rules where we can handle what we're doing.
Are you talking about the Redruth decision?
I am talking about Roth versus Stanley, and around in the circle back to Rydell, and perhaps a little shaking of Redruth, a pinch of Redruth, just to give us some, perhaps give defense attorneys a taste of heaven if in the event we get a Redruth decision. I'm assuming for the purpose of this particular case that we don't have a Redruth issue, because presumably this court would decide this case on its easiest merits, and that is that it's constitutionally protected as a matter of law. What we have here, in fact, is a very interesting proposition. Mr. Miller, as the evidence somewhat points out, is president of a corporation which sends out advertising brochures. The center of the brochures, or the place where the mailings originate, was in Covina, which is in the county of Los Angeles. In the county of Orange, which is the neighboring county, a prosecution was commenced. In addition to this prosecution for violation of Section 311.2 for the brochures, which are illustrated history of pornography, sex orgies illustrated, and a book entitled Man/Woman, there were several prosecutions initiated.
Exhibits in this case?
I believe they have been sent up. These exhibits were and are described, if you please, in the opinion of Judge Arguelles in the Los Angeles Municipal Court, East Los Angeles area. His description of what the material contained is at page 18 of the reporter's transcript, and it repeats what respondent is trying to foister upon this court, that there were pictures of, if you please, cunnilingus, or oral copulation, sodomy, oral intercourse between a man and a woman. The fact that these particular pictures are drawings, artistic, seems to be irrelevant. The fact that some of them are copies of frescoes which come from Indian art, Japanese art, also seems to be irrelevant, since it becomes the job of the jury to determine under certain rules laid down whether or not they are, quote, obscene or not obscene. And also the job, apparently, of some experts to determine whether the average person looking at the pictures as they come to him through the mail, the average non-consenting adult, let's assume that that's the class we're talking about, that the average non-consenting adult, upon seeing these pictures, will have an immediate appeal to his prurient interest because of this exhibition. It doesn't seem to follow. There does not seem to be much empirical evidence, and I have a red light.
We'll resume in the morning, counsel.
Thank you. Mr. Chief Justice and Court, please, to continue with my preface, if you will, to the argument. Yesterday I was expressing the proposition that perhaps the court has not become acquainted with the realities of the situation at which lawyers and perhaps judges are faced with when approaching an obscenity case when it is put into the criminal context. For instance, the Fifth Circuit in a case of U.S. versus Groner, decided January 11, 1972, Judge Thornberry expressed some apprehension that he could not understand what was happening in the obscenity field, and certainly could not make any determinations for himself as to what was obscene or not obscene in the absence of expert testimony, and also expressed that he thought
in line with several other cases, that a national standard as far as contemporary standards would seem to be just the ticket under the circumstances that material goes between states. The case at bar is very interesting, I think, when you examine the history of this case, Mr. Miller, and it illustrates, in my opinion, why Harris v. Younger was decided wrongly. Mr. Miller has a company which publishes, and it's in Covina, which is in the county of Los Angeles. They send mailers out, brochures out. Brochures went to Los Angeles County, Orange County, San Diego County, and to the various states. And you must understand that within the various counties there are district attorneys and city attorneys who are responsible for bringing prosecutions, and it's up to their discretion as to whether or not a prosecution will be had, that is, a complaint filed. Now, in Mr. Miller's case, there were prosecutions filed in perhaps 15 different municipal courts on the same brochures within the county of Los Angeles in different municipal courts, different district attorneys, deputies of the same county, prosecution in Orange County, prosecutions in San Diego County, and this is what happened in Orange County. First of all, in Los Angeles County, we brought a motion, and this is illustrated in the clerk's transcript before Judge Arguelles in East Los Angeles Judicial District, and the motion was presented in which we had expert witnesses testifying that the material was not obscene, was constitutionally protected, and Judge Arguelles made a determination dismissing the action that the material was in fact protected as set forth, for the reasons set forth in the various cases. After that, the Orange County prosecution was started. Same brochures, same defendant, same plaintiff, to wit, the people of the state of California. So what did we do in Orange County? We went to the first trial judge and we made a motion to dismiss on the grounds that it was constitutionally protected, presented expert witnesses, the people presented none, the judge denied the motion. We then took a petition for writ of prohibition to the Superior Court in Orange County to stay the proceedings. Writ of prohibition denied out of hand. Appealed to the Orange County, to the Court of Appeals, Second Appellate District, for a stay, a writ of supersedious. Denied. Supreme Court of the State of California. Denied. No stay. We then went habeas corpus route through the courts, alleging that the material was protected. We went to the Superior Court, the Court of Appeals, Supreme Court, all denied out of hand. Also alleging, if you please, in the habeas corpus proceedings that there was a res judicata, an estoppel, Ash versus Swenson, Waller versus Florida, decided by this court. The material is protected, it can't be prosecuted. Denied, out of hand. No court to date, as a matter of fact, if you now consider the fact, and I think I misspoke myself, that I said a 7-week trial, it was not, it was a 7-day trial. But this is a very short trial for obscenity cases as a rule. After all of these pre-trial proceedings in which we were trying to get nothing but an adversary hearing, we then went to trial with a jury, a conviction, an affirmance without an opinion in which the appellate court completely abdicated its own responsibility, and that is to review the material, a simple affirmance, and remanded it, and finally an appeal to this court.
Mr. Marks, following the conviction, you appealed from the appellate department's affirmance to the Court of Appeal for discretionary review. Is that right?
I asked for what is called a petition for certification, and this is discretionary with the appellate department of the Superior Court whether or not they want to certify the important question over to the Court of Appeals.
But doesn't the Court of Appeal also have a right without certification to grant you a discretionary hearing?
That is correct. They can. If the opinion is published, if there is a published opinion in the appellate department which is entirely discretionary with them, then the Court of Appeals has the right to exercise its discretion to determine whether or not it wants to decide that question and take jurisdiction.
Did you have no right after the conviction to petition the Supreme Court of California for discretionary review?
None. absolutely, as a matter of fact, it is expressly prohibited that you do make such an application. I believe there was a case that came out that said once your petition for certification is denied from the appellate department, you have no right to appeal that that it's purely discretionary under the court rules.
Where are the opinions in the California courts in these cases?
The only opinion that is in any court, in the California courts, with respect to the material in this case is found in the clerk's transcript at page 17. That's Judge Arguelles' memorandum opinion and order, and this is the case out of the Municipal Court of the East Los Angeles Judicial District. It is not in the appendix, it is in the clerk's transcript. And this was the basis of the res judicata claim that we had.
Mr. Marks, what was the sentence Mr. Miller received? I failed to find it in your brief.
60 days county jail on this particular charge and a $1,000 fine, as I recall, which has been stayed pending this appeal. To continue, taking this history of the case procedurally, I have the following quote, which I picked up from a recent case, and that is, I entertain more than a mild suspicion, however, that this is an exercise in futility, that the court is merely marching up the hill only to march right down again, and it is time we become just a little realistic in the face of a record such as this one. U.S. versus Tucker, decided January 12th this year. Mr. Justice Berger said that in a different context.
Well, that was Mr. Justice Blackmun, and I agreed with him.
I think that in taking the history of this case, if you please, it illustrates the futility of making a decision by this court in the ordinary manner as to whether or not, for instance, contemporary standards are national or local, because it really doesn't matter. The judges below simply will not pay any attention to the cases. They do not rule as a matter of law in obscenity cases. It is a very visceral reaction. You get a shock value on obscenity in no other cases. They, in my experience, do not function. And I suggest to the court that the answer to the dilemma which is posed, the paradox, the irreconcilable conflict between the cases, is that this court set up a series of rules by which courts must act in obscenity cases. And that is that they must, for instance, prior to initiating a criminal proceeding, have the type of hearing on the material which is set forth in Friedman versus Maryland, Blount versus Rizzi, and there should be rules whereby they are compelled to either state that it is protected or not protected, so that somewhere along the line, before the criminal process starts, the person who is going to be involved in a criminal prosecution will at least have the vaguest idea that what he is trying to purvey or sell is not or is within the marketplace. And I give you the following example, and I say this is why I believe it comes within the context of the certiorari questions, because we have here the question, national standards or state standards. If we do not have national standards, I think our brief pointed out that in the area of film, in the area of books which cross state lines, there must be a common standard, because otherwise State A can impose unreasonable burdens upon what kinds of films are shown in the motion pictures theaters in their neighborhood. Perhaps one community, local community or state, doesn't like R films because R-rated films have sex portrayed in them. Some X films sometimes have more violence than an R film and less sex. It depends upon the individual idea of the censor himself.
Well, let me ask you about this administrative process you were just suggesting to be interposed before a criminal proceeding starts. Are you suggesting something like the old-fashioned board of censorship to take a look at it first and advise the publisher?
I am suggesting a process whereby if there is cause to believe, a probable cause to believe that a material which is being sent out or is being sold on the stands is or may be violative of the penal statute or may be obscene within the area of the state statute, that the judge issues a show cause order and perhaps even a seizure warrant. The material is seized. It's brought into court. 1-day hearing. Expert testimony. 2 days to make a decision. The decision should be in writing, stating the judge's reasons for believing that the material is or is not protected. At that point, you have some sort of adjudication, because the real proposition and problem is with Scienter, Mr. Miller and every other seller of pornography has, just as in this case, a judge which says the material is protected in one jurisdiction to no avail in another, because he can't get any recourse. If he goes to a jury trial and gets acquitted, the judge in the next jurisdiction says, well, I don't know what the acquittal was based on. Maybe it was just that the jury wasn't satisfied beyond a reasonable doubt that he was the person who sold it. Maybe they weren't satisfied with Scienter. The criminal process is not equipped to deal with obscenity questions. It never has been and never was. There has to be a different type of process dealing in the civil area to deal with the sensitive area of suppression and censorship. That is why I suggest, for instance, that the national standard has to apply, but it has to apply in the area of interstate commerce. It has to apply also. We have a very interesting question: what happens with the full faith and credit clause? If one court says it's obscene in one state, doesn't this bind another court under the full faith and credit clause? Or if it is obscene, what happens? Is the man entitled to plead the other judgment in bar as an estoppel, or just as a defense in the grounds that he has no Scienter? How could I possibly know that it's obscene if a court said it's not obscene?
Mr. Mark, in the case tried in the municipal court from which you're appealing, was the question of federal versus state standards raised by a request to charge the jury?
There was no request to charge the jury on the national standards. The charge was made in the terms of state standards, because at the time there was, and still is, a case of In re Giannini, which is cited in our briefs. And in the Giannini case, our California Supreme Court said in the matter of dancing, topless dancing, they said at least the standards have to be statewide, because there has to be some sort of uniformity, although they felt that you can't cross a dance act across county borders, and obviously the local community should be the best judge, but there at least has to be some uniformity. Applying that rationale of the Giannini case to motion pictures, books, those magazines that travel across state lines, it would seem that the national standard is the only standard which has any reasonable grounds. Now,
can you help me out on one other thing? Your statute, I think, is Section 311E, and this was amended about the time of the prosecution here. Am I correct in assuming the indictment and the trial were after the amendment?
It's a complaint, Mr. Justice Blackman, but I believe both were after the amendment.
So it's under the new statute then?
Well, no, because the acts were before the amendment. So the question was at one time whether or not you have the definition, the original definition was knowing the matter to be obscene. The second definition was having knowledge or being aware of the contents of the matter, which to me is just as vague a statement as some of the other definitions that we have had regarding obscenity.
Well, then we are dealing with the old form of the statute in the Constitution.
I don't know, because if you read the instructions that were given, one of them says that the person to be convicted, Mr. Miller had to know that the matter was obscene and know all of the elements, that it went beyond contemporary limits of candor, etc. And a second set of instructions said that, very confusing, that it only meant he had to be aware of the contents of the matter.
Well, this is why I asked the question, because I'm confused too.
Well, it's a very confusing subject because to some judges, and I suppose lawyers, it means the same thing. To me, it doesn't. It means an entirely different thing because of being aware of the character of the matter. That's what the new section reads. And what the character of the matter is a very, very elusive quality. Does it mean that the character is that of sex? Is it the character of violence? Is it the character of sadism, sadomasochism? One of the characteristics of pornography? We do not know. It's probably whatever the jury wants to think it means. One of the big problems that comes up in the prosecution or the trial of a case and the defense of a case is this question of the various and I might say paradoxical rules that this court has set up. Because in Roth, the court said that free speech, and I'm paraphrasing a little bit, but paraphrasing, in Roth, the court said that obscenity is not speech. And then in Stanley versus Georgia, the court said that obscenity is speech. And then in Rydell, the court said we adopt both Roth and Stanley and we don't vary one way or another, so we come to the unusual proposition that speech is not speech. I adhere perhaps, and this is my final argument, to the add-on theory of constitutional protection. It appears that from reading the various cases that if you have a First Amendment protection and you add on, for instance, the Ninth Amendment, the right to privacy as in Stanley, 1 and 9 equal 14, and you have a constitutional protection. In our case, we have a few other add-on protections that Mr. Miller should avail of himself. He has the First Amendment protection. He has the Fifth Amendment, which is the res judicata or estoppel. He also has the Ninth Amendment, so in this case we have 1, 5, and 9 equaling 14, and he should be able to have a reversal just on that theory alone. Getting back to the more mundane, I say very seriously, we need guidance from the court, this court, and I think it cannot be done in the framework of deciding whether national or local standards apply because the courts below do not know how to apply them, even if it is shown to them what it means. They work on a case-by-case basis, and I had one judge say to me, when I pointed out Blount versus Rizzi, he says that only counts if the defendant's name is Rizzi and the plaintiff's name is Blount, and otherwise it's distinguishable on that fact. So set us up some rules, give us some guidance, let's get this type of action out of the criminal area unless there is a distinctive criminal case with knowledge and the type of pre-warning that is generally accepted as a part of due process.
Well, I've read the opinion you referred me to, and that opinion results in the dismissal of the complaint.
Yes, sir.
And the judge held that this material is constitutionally protected.
Right. In the East Los Angeles Municipal District.
Is that the only opinion in this case?
Yes, there is no other opinion.
And then what happened?
He was prosecuted in the Orange County Municipal District.
Where is the opinion in that?
There is none.
Where is the record in that?
The record in the Orange County case, it consists of the appendix, which is a jury verdict of conviction and an appellate order which says the conviction is affirmed. Period.
We don't have any of the evidence?
You have the brochure on which they related it. You have the reporter's transcript in the...
Did the expert witnesses who testified in this Los Angeles case testify at the Orange County case?
Yes.
The same effect?
The same effect. You see, in Orange County there was a pretrial hearing in which we had our experts testifying, and the people offered no evidence. Then on trial, the people then offered their experts who said the matter's obscene, or whatever other elements they thought were present, and Our experts testified to the contrary, and it became the battle of experts, and the jury looked at the material and said, guilty.
Where are the instructions to the jury?
The instructions to the jury are found in the clerk's transcript, and I believe in a part in the deferred appendix, which is the this brown. Sorry.
Do you think that Roth should be overruled?
I think that Roth should be clarified to show what it actually meant, because it makes no sense the way it reads now in light of subsequent opinions, because of the way the court has ruled, for instance, in Redrup, and there's various qualifying matters with respect to Roth, and then all of a sudden out comes Rydell in 37 photographs and says, that doesn't mean what we said. I think it should be overruled. I think that the First Amendment should bar criminal prosecutions in the absence of direct knowledge. I can't go on.
In absence of what?
In the absence of direct knowledge, a prior knowing hearing that the matter is probably within the context or framework of prohibited speech.
Do you suggest that in your briefs that you've filed with us that you have laid down this standard that you want us to adopt that will solve all the problems?
No, I'm just saying that this seems to be, after going through the various cases and the paradoxes that are arisen in a decision by the Fifth Circuit as late as January 12th, that there is no other answer, because you can't resolve the decisions of this court and the various justices, and the only resolution is to take everything and say, okay, that's the way it is, speech is not speech if it's obscenity, and then set up a set of rules so that the judges will know exactly what to do when they get with an obscenity case. And I say bar the criminal prosecution, take it out of the criminal area until you have a prior hearing as to the obscenity or non-obscenity of those. Thank you, Judge.
Very well, Mr. Marks. Mr. Capizzo.
Honorable Chief Justice, may it please the Court. Initially, I'd like to attempt to set the record straight in this matter. In early April of 1969, a complaint was filed in the municipal court of the Harbor Judicial District for Orange County. And thereafter, on April 16th, 1969, a demurrer was filed by Mr. Marks, the defendant in that action. Thereafter, an amended complaint was filed May 9th, 1969, and following the amended complaint, the same demurrer was held to apply to the amended complaint. The hearing on the demurrer under California law is limited to the face of the complaint. However, Mr. Marks did introduce expert testimony at that time, expert testimony related to the obscenity of the material in question, and that was not controverted by the prosecution, simply because on a demurrer, no evidence can be taken. The inquiry is limited to the face of the complaint. Thereafter, there was an appeal to the appellate department of the Superior Court in Orange County, and the denial of the demurrer was sustained. Now, this record...
I gather that Mr. Marks, I'm not sure I understand it, but I gather that his complaint is that the issue that he's tendering is akin to decisions in this court on the vagueness test for constitutionality of criminal statute. You understand it? That what we have done, what we've said, the standards are too imprecise, too vague to pass muster under criminal constitutional law, due process.
I understand that to be one of his contentions, Mr. Justice Douglas. However, I think he's also made the contention that action in an adjoining county constituted res judicata.
I understand that too.
I tend to disagree with him. I think depending on how the standard or the definition announced by this court is interpreted, it's workable. I think the procedural aspects, and there must be a clarification.
If California adopted the statutes saying that it's a crime to publish book that is without social redeeming value, would that pass muster by the California Supreme Court decision?
Well, California has gone one step beyond Roth and has adopted a position that has not been concurred in by a majority of this court as being constitutionally required, in that the California statute requires that the prosecution establish that the material goes substantially beyond customary limits of candor, that it predominantly appealed to a prurient interest, and the material considered as a whole be utterly without redeeming social importance. So by statute in California, all three elements must be established by the prosecution and must coalesce.
In other words, the California statute adopts two of the bases of our Red Rock decision.
Well, it adopts the definition of obscenity as first propounded in Roth and then later expanded upon, I believe, in Memoirs, the utterly without redeeming social importance aspect. And I don't think a majority of the court concurred in that requirement, but nevertheless, California, by legislative act, has added that third requirement. And that's why there were experts produced by the people on all three of those elements definition, and the jury was instructed as to all three and instructed that they must coalesce. Nevertheless, counsel points to the action that took place in Los Angeles County, and with respect to that action, in the opinion of the Los Angeles County Municipal Court judge, that was never directly pointed out to the judge in which the action was pending, the instant action was pending for trial. It's part of the record, the clerk's transcript in this appeal, simply because it was an exhibit to a petition for writ of prohibition that was filed in our Superior Court attempting to prohibit the misdemeanor prosecution. And in filing that petition for prohibition with our Superior Court, he apparently lodged a courtesy copy with the municipal court, and that's how it became a part of our record. Then thereafter, just prior to the trial, he did make a motion to dismiss on the basis of res judicata, but no evidence was presented, and there was no hearing on that particular motion. And in particular, the opinion was not a part of that particular motion.
In the East Los Angeles proceeding, was a jury actually impaneled in that case, or was that a dismissal on a preliminary motion?
That was a dismissal on a preliminary motion, Mr. Justice Rehnquist. It did not go to trial. It was what's known in California a Noroff motion, a determination of the question of law, the mixed question of constitutional fact and law.
Didn't you say it was on demurrer, or was that another case?
The
demurrer to the complaint.
In Los Angeles County, I believe it was a motion to dismiss and demur based on two cases, People versus Noroff and Zeitling versus Arnberg, as I recall. Now, the appellant contends that this court, or at least members of this court, have in the past suggested and and this court should continue to conduct de novo hearings to determine obscenity, vel non. He further suggests that in reaching that determination of constitutional fact, a mixed question of fact and law, the judge, when applying contemporary standards for customary limits of candor, should adopt a national community standard. What appellant requests may be easier for this court than for other courts because the scope of this court's judicial inquiry is nationwide. However, I suggest even for this court, it's not an easy task and is in fact an impossible task. Appellant also suggests that each judge from the trial level through each level of review should redetermine the issue de novo using the same test, the national test. And I would submit that this is practically impossible. Local trial appellate and state Supreme Court justices just don't have the sufficient scope of judicial inquiry to apply a national standard. With respect to their contact with national standards for customary limits of candor, I would suggest that it is no more broad than the average potential juror. And I think the case which counsel has just called this court's attention to this morning, the Fifth Circuit case, demonstrates that when Judge Thornberry indicates that he is not sufficiently qualified to determine customary limits fully under.
Get experts who might testify at the national standard.
Yes, Mr. Justice Douglas. In fact, Mr. Marks has suggested experts, but I think that demonstrates another problem that will further compound the problems that are already existing. Experts may be fine for the initial judge, the trial judge, who can examine the witness, determine his credibility, watch the demeanor while he's testifying, and all the things that a trier of fact generally does. But what position does that leave the appellate judge, the reviewing judge in? If there are conflicting experts, how does he determine credibility of the varying witnesses? It's totally impossible, and to say that the reviewing judge would determine credibility would be a substantial departure from firmly entrenched rules of appellate review.
I suppose if that's true, what you're saying, I gather it is, it would be also very difficult for a publisher, an author, to know when he'd crossed the line.
I don't think it's that difficult for a publisher to know when he's crossed the line. In fact, the reporter's transcript in this particular case, I believe it's volume 2, around page 50, give or take a few pages, indicates that Mr. Miller indicated to the person who was sending the material out that the brochures themselves he felt were borderline, but the material itself that they were advertising he considered to be pornography. And the brochures are nothing but the more graphic depictions of sexual activity that are contained in what he himself described as pornography. So I think...
This was a plea of guilty, no?
No, it wasn't trial. It was a trial. The statement made by Mr. Miller came in by way of one of the persons who was stuffing the envelopes and assisting in the distribution. I would suggest, however, that if we do apply the approach in the instant case that each level of court must determine a constitutional fact, law, question, that it's readily apparent that in this case, as far as that constitutional fact is concerned, that this material is obscene no matter what test is used, whether we use a local, state, or national community. It exceeds candor of any community. It predominantly appeals to a prurient interest and is utterly without redeeming social importance. The California test. Having concluded that it's not constitutionally protected, it's submitted that this material should fall into the same category as any other conduct that a state can regulate by police power, any other conduct which is not itself constitutionally protected. And the states, in regulating that other non-constitutional conduct, can define it in any manner they wish. The states vary in the definition of robbery from state to state. Burglary varies from state to state. And assuming this initial constitutional fact law determination is made by a judge and it's determined that it's not constitutionally protected, then the states should be free to adopt whatever standard they wish, just as they do in other areas of criminal law.
Has California at any time undertaken to use nuisance statutes or local nuisance ordinances to deal with pornography and obscenity?
Yes, Your Honor. In the County of Orange, we've utilized what's known as a Red Light Abatement Act to abate as a public nuisance places that are used for lewd purposes, prostitution and assignation. More often in the area of live entertainment than in the area of printed material. Would submit, however, that it's not necessary to do as appellant suggests to determine this constitutional fact in this manner when looking at a state prosecution under state law. The Constitution permits the states to adopt a standard that the state chooses as long as the standard is compatible with due process and in isolating obscenity. As Justice Harlan said the states by the due process liberty provision of the 14th Amendment is not held to the same test as is the federal government under the First Amendment. And as Justice Harlan indicated, that's readily apparent from the language of the two amendments themselves. The first provides Congress shall make no law, and obviously we can't apply that in its precise terms to the states through the Fourth Amendment because Congress doesn't exist in the states. So obviously we have to do some initial editing. And additionally, it's rather obvious that if, in enacting the 14th Amendment, it was the intent to restrict the states as the first restricts Congress, it would have been very simple, and to have so stated that the states are prohibited from enacting any law abridging the freedom of speech. I would certainly not suggest that those persons who framed the 14th Amendment were so imprecise or so inarticulate that if that had been their intent with the background of the First Amendment, that something consistent with the First Amendment could have been specifically provided to the states.
Is there any reason why California is limited to using its nuisance procedures against what you call live or live obscenity or obscenity which is essentially conduct? Would it be available, in other words, to use it against books or moving pictures?
I don't know, Your Honor. We haven't progressed in our cases that are pending against a particular bookstore to the point where we have applied it. There have been acts of lewdness as well as the sale and distribution of books from that particular bookstore that have gone on inside the premises. The act itself states that it applies to places of prostitution, assignation, or lewdness.
Although your brief doesn't say so in these words, I gather from your oral argument you think that the decisions of this court making applicable the First Amendment to the states were wrongly decided.
Yes, Your Honor, in its express terms. I feel that
you think that Jong and all the other decisions should be overruled in that regard?
Well, I would suggest that again, the positions taken by Mr. Justice Harlan and expressed by him in the Roth case is entirely reasonable and is consistent with the Constitution. When we're talking about the deprivation of one of the fundamental liberties without due process of law, the inquiry should be whether or not the state action so subverts the fundamental liberties implicit in the due process clause that it cannot be sustained as a rational exercise of power. And I would submit that adoption by a state of a local or statewide standard for limits of candor as a portion of the definition of obscenity is not subversive of fundamental liberties, but is actually a rational exercise of power. Whether I'd suggest that neither practicality, reason, or the Constitution require a national standard for customary limits of candor as suggested by the appellant. Initially, I'd suggest that practicality demands that something other than a national standard be used. How is a national standard to be determined? Wholly apart from the legal question, the mixed question of constitutional fact law, as a matter of fact presented to the jury. How is a national standard to be determined? Well, as far as that factual determination, I would assume that experts could testify. However, in this case, an expert testified as to the statewide standard. An expert was an employee of the Los Angeles Police Department. It took him 30 days to conduct his survey and analysis of the state and 5 years on the job. The city of Los Angeles now charges $400 a day every time one of their experts goes outside the city limits to testify to recoup the cost of conducting their survey and updating their survey. Can you imagine the additional cost that would be involved if that expert had to spend 30 days traveling each of the 50 states? Why, it would take him 50 months just to complete his survey. And long before he completed his survey, he would have to update it because it requires contemporary community standards. So if we multiply the cost by 50 times 400 and the time 50 times a month, totally impossible and impractical. Now, I'm not suggesting that cost alone is a factor that should cause us to overlook any constitutional right. I'm simply suggesting that the Constitution itself does not require experts, and it's impractical to prove through experts a national standard. Reason also requires that a local or state standard be adopted. Obviously, one local area will accept material that another local area will not. A national standard could very likely prevent a local community that had liberal attitudes and would accept material from receiving that material because of the restrictive influence of a conservative community some 2,500 miles away. And the opposite is also true. The conservative community would be forced to accept material because of a nationwide standard that is diluted by a more liberal standard of a community, again, 2,500 miles away. Thus, adoption of a national standard would have just the effect that the appellant in this case, and the amici, are suggesting is undesirable. It would have the result of making us all one, making us all little tin soldiers out of a mold, all receiving the same material, the same standard, and would not provide for differences from one community to another. I would suggest additionally that the Constitution supports a state or local community standard. Initially, in Roth, this court used the term community, and in spite of the dictionary definition that's in the footnote to Jacobellis, I suggest that the customary meaning of community is a local community, the area in which people shop, work, live, and entertain themselves. And I think that definition of community is also consistent with the same paragraph of the dictionary referred to in that footnote to Jacobellis, which defines community as society as a whole. Additionally, it's constitutionally permissible to accept a local or state-wide standard because of the definition announced in Roth that the community standard must be contemporary with the times. Without that term contemporary, we would be stuck, I would assume, with the same definition of obscenity that existed in 1791 when the First Amendment was adopted.
But are you suggesting that a standard would become outdated and therefore not contemporary after the lapse of 2 or 3 years? Is that what you think contemporary?
I think it must be a standard, yes, Mr. Chief Justice, that exists at the same time as the distribution or the time of the crime. I think it has to exist in tune with our particular times. It's not a community standard that existed in, say, 1850 or 1791 because of the term contemporary. Thus,
there's quite a difference between saying that we aren't bound by the standards of 1791 and saying that the standard is outdated if it's based on some sort of a survey made in 1965. I get it that you're suggesting that this has got to be kept up to date almost on a month-by-month basis to see what people are thinking just lately.
I think that is true, Mr. Chief Justice. That
you've set out an impossible task for yourself, haven't you?
I think it's a task that has been required of us by the term contemporary, and the California Supreme Court, in the case of N. Ray Giannini, requiring that community standards be established by experts.
Of course, Giannini, as I read that opinion, dealt only with a dance in a local tavern in a town in California, right?
Yes, Mr. Justice Douglas, however...
We're dealing here with a big Doubleday and Company and other big publishers of books and tracts.
No, in this case we aren't dealing with Doubleday.
No, I say, but the problem we're dealing with deals with a big distribution system that's national and so on. How does your local standard fit the normal pattern of the American book publishing business or magazine publishing business?
Well, the same definition of obscene was applied to the topless dancing at In Re Giannini as is applied to printed matter in California because of the California Supreme Court statement that the dancing is an expressive conduct.
My question really relates to whether or not in this area we're not really in the area of a common market of literature and ideas. It requires a national rather than a local standard.
Well, I'm suggesting that
California the privilege of doing what they want with topless dancers.
Yes, I submit that the Constitution permits a changing standard based on geographical lines, even if the material is distributed nationwide. Now, in this case, we have no evidence that the material was distributed nationwide. The only evidence we have is that it was mailed in either Los Angeles or Orange County, and it was received in Orange County. And that's the only evidence, as far as I'm aware, in the record indicating the scope of its distribution.
Mr. Capizzi, if in fact the court were to adopt a local or community standard as opposed to a federal standard, wouldn't the guarantee of jury trial in each case be itself some way of evidencing the jury's reaction, be some evidence of the local community's standard without the necessity of expert testimony?
Yes, Mr. Justice Rehnquist, I believe that it would. It would relieve this court and appellate courts from determining that which they are not really capable of determining on their own, the constitutional fact law question. It would eliminate that from consideration, and it would permit us to rely on the jury verdict and, assuming there was a conviction, a sufficient evidence test to determine whether or not it complied with due process. And I think the changing standard from one geographical location to another, again, has constitutional background simply because we do have the one variable, as I was suggesting, the contemporary community standards. It's a changing standard, and it must be a standard that's contemporary with our time. So why is it so inconsistent to say we have another variable, a geographical difference, a variation that would differ from geographical location to another? We have procedure for punishing utterances in one location and not in another. Fire in a crowded theater is punishable. In an open field, it's not. The words are the same as the location that constitutes a clear and present danger, and maybe that's what we're saying in this case. If one community can consider matter which violates its particular standard for limits of candor dangerous and within its police power, and yet another community really wouldn't so consider it. The adopting this test, the appellate courts could then use the sufficient evidence test to review convictions, and the time saved delving into other issues. In other, whichever test is used in a particular case, I would suggest that the judgment should be affirmed. If we use a national standard, I would suggest that the statewide standard in the state of California is a liberal standard, and in effect had the net effect of requiring of the prosecution a greater burden of proof than if the national standard had in fact been established and could be established. If it's a statewide standard, that was what was done in this case, and if it's a local standard, again, it operated to the benefit of the appellant to use a state standard because the statewide standard, I would submit, for the state of California is, again, somewhat more liberal than the conservative standard of Orange County, and again, required of the prosecution a greater burden of proof.
Let me ask you, you urged the local standard. Would you say well, I'll preface this by saying let's assume that the First Amendment applies to the states the same to all the states the same way. Would you say that if California can use a local standard, that there are no limits to what might be held to exceed the standards of candor in the community?
No, because under California law, it would still be required that the prosecution prove that the matter taken as a whole predominantly appeals to a pertinent interest, and the matter taken as a whole is utterly without redeeming social importance. However, I would suggest that
in any case, it wasn't the local standard. That's the dissent thought that it should be the local standard.
In any case, the California Supreme Court
said
that it was a state standard. And in California, we're bound by a state standard because of the edict of our state Supreme Court. I'm suggesting, however, that the Constitution requires no more than a local standard. And if the states, in enacting their laws, wish to adopt a state standard or a national standard, they should, under the 14th Amendment, be free to do just that.
In other words, you, as a matter of federal constitutional law, you take the view of Justice Burke in dissent.
Yes, Mr. Justice. Submit the matter unless there are further questions.
Very well, Mr. Casey. Mr. Marks, I think you have consumed your time. The case is submitted. We'll hear arguments first today in number 7073, Miller against California. Mr. Marks.
Mr. Chief Justice, and may it please the Court, we're back again before the Court since January of this year to re-argue the matter and to discuss with the Court what one of my colleagues described as the continuing saga of life in the pits, or what goes on in the lower courts, because we don't know what actually this Court is saying with respect to the pornographer. The second proposition that we have to this Court is that a person charged with the crime of obscenity should have perhaps as much rights accorded to him or her as, let's say, a parolee who is having his parole revoked, or perhaps a juvenile who is being declared a delinquent. Perhaps I can explain. As I said, there is a continuation of horrors. In January, I described to the Court what happened in this case, what a defense lawyer had to do to go through a trial or proceeding in order to at least attempt to have some kind of hearing as to whether or not the material was constitutionally protected. This included pretrial hearings in which evidence is presented by the defendant, none by the prosecution, and a complete denial of any real hearing or real, in my opinion, understanding by the trial judge as to what the issues were. Since that time, to give you an example of what occurs in the courts below because of the erratic, if I may say, types of decisions which emanate from the higher courts, and perhaps the visceral reactions that occur with various judges, is I've been in 3 trials since I've seen you. And this is this court in Wiener versus California held certain material to be protected vis-a-vis Red Rupp. Now, the Wiener materials were down in San Diego, and they involved some motion pictures and some films. So I had 2 trials in Los Angeles in which I attempted to have the judge take some recognition of the materials in Wiener so that there could be a comparison of what was protected and what was not protected. Now, the interesting proposition is that the prosecution...
Was this a jury trial, Mr. Ward?
No, we waived jury. The interesting proposition in the first trial that I had was that the prosecution had an attorney who was reasonably experienced in the pornography field.
this prosecutor was unwilling to admit to the court, as were the police officers who are really the experts, because in Los Angeles they have a vice squad with pornography experts that travel through in the state, and they know what's going on in the state, refused to admit that the materials in my case were the same as the materials in Wiener, and as a matter of fact refused to take judicial notice of the fact that they were the same, and there was simply no way to get the Wiener materials from San Diego to Los Angeles because they had been introduced into another case in San Diego to try and persuade a second judge that the materials were the same and therefore protected.
Mr. Marks, this perhaps doesn't bear precisely on the point that you're arguing, but you said you waived juries in both these recent trials?
In the last, the first case I did because the judge that we finally got was, in my opinion, sophisticated enough to understand what was going on.
Well, as a matter of trial tactics in defending cases like this, do you ordinarily prefer a bench trial to a jury trial?
No, absolutely not. No, because if you're allowed to have the procedures which the California state allows you to have, you should have under Noroff a real pretrial hearing to determine whether or not the material is obscene.
Which then ends the whole case.
Which would end the case. But the unfortunate proposition is, as I was going to point out, is that the judges simply don't follow the law. They don't. Perhaps it's merely a matter of buck passing. And as former President Truman said, the buck's got to stop somewhere.
But I take it if there's a determination of obscenity at this pretrial proceeding, that is not conclusive, of course, at the jury trial, is it?
Well, that's a very interesting question. Of course not. Of course that...
You may still argue to the jury the non-obscenity material. Are you?
Of course.
Yeah.
Yeah. Sometimes what the judges feel or believe is, and there's some California case law to that effect, although it really does not seem to be appropriate, because ordinarily we're talking about a misdemeanor case in obscenity. The only time you get into a felony case is when it is bootstrapped into a felony by virtue of the charge of conspiracy, which makes it a felony, or because a person has a second offense. Now, if you have a misdemeanor trial, there is no such thing as a preliminary hearing. So the California Supreme Court gave misdemeanants in a pornography case essentially what might be called a preliminary hearing through the Noroff case, in which you're entitled to have a hearing to determine whether there's obscenity. Now, some judges believe that this only means probable cause.
Are misdemeanor cases tried before juries?
Yes. Some judges believe that this obscenity issue and determination means only probable cause to believe it's obscene, so it'll go in front of a jury. That is not my understanding of the law, but there's no clear-cut decision on that proposition. In a felony case, if you happen to have a felony, then you have a preliminary hearing, and in that preliminary hearing there is a probable cause situation to believe that a crime has been committed. Again, there is a case out of California called Luros, which says that the grand jury does not need any evidence to make a determination of probable cause so that the matter can be brought before the petite jury for a trial. But then we have, again, this intermediate Noroff step, which supposedly is supposed to have the judge independently make a determination of obscenity. It's always been my expression or opinion that the proof of the prosecution as to obscenity in a pretrial hearing has to be also beyond a reasonable doubt, because if it's not obscene, it can't be prosecuted. But, as I say, this leaves the law in a state of flux, and nobody really seems to care. I was talking about the trials that I had. In any event, what happened was the two defendants had been arrested in practically the same situation. They were the type of defendant that you will ordinarily find in, as far as I can determine, 90 to 95% of the cases which come before this court or before any obscenity court, i.e., a bookseller, a motion picture operator, somebody who is in business, not the skulking pornographer who goes out into the alleys and calls in the little kids and says, look at the dirty pictures. He's there. He has a store, he has a business, he has a movie theater. He invites no one in except by the advertisement. Generally, if you take a look, for instance, you open your Washington, D.C. newspapers, and there's advertising for what's known as adult films. And it doesn't pictorially describe what's being shown. It gives the title, and the persons who are the aficionados or the who want to go to the theaters know what's going to be shown in the theaters by the fact of the title and the place where the theater is, and they go and see it. But I'm talking about the client, the person who is in business. He's operating a store, he buys film, he buys books, and he sells it to the persons who come in. Ordinarily, there's no such thing as pandering, as was described in Ginsburg. Simply a police officer walks in, sees a piece of material that he doesn't think is worthy of his consideration, either makes an arrest on the spot, although that is now out in California, but generally will go back and make an affidavit that he saw a dirty book or a dirty picture, and he will describe why it was dirty, and then some magistrate will sign a search warrant, and he'll go in and seize that. Sometimes
he doesn't buy the book and then take that to the magistrate.
Sometimes they do it, but very seldom. Apparently there is not enough funds given to the vice squad to purchase this type of material. They have other areas. They generally go in and they look at the pictures. My two clients happen to have arcades on Main Street where you have peep shows and little motion picture theaters. Police officers went in, saw the films, went back, described what they saw or what they thought they saw, gave the affidavit to a magistrate, authorized a seizure. They came back a few days later, seized the film, took it to the police station, then had an arrest warrant issued. Both clients were charged with felonies because they had a prior misdemeanor.
Is the seizure for evidence in a prosecution or for destruction of evidence?
Evidence. In the first case, the judge, after I'd waived jury and after I'd been able to present an expert who had seen the Wiener material and seen this material, which was called simulated, testified it was exactly the same, and I presented to the judge a list of cases that and showed him how the material was exactly the same. Finally read the material, and lo and behold, after an entire trial in which the police officers testified in their expertise as to what was obscene and not obscene, and my expert had shown the comparison between Wiener material and these materials, the judge granted my motion to dismiss on the grounds that the material was constitutionally protected and returned the films to me. The next case was exactly the same. It was another person who had an arcade next door. I went into the second judge, who had never had a pornography case, never had an obscenity case, but of course knew what was obscene and not obscene, tried to persuade him that this case that I had today was exactly the same case as the case I had yesterday, and that, in fact, the ruling of the judge before was res judicata, because it wasn't an acquittal, it was a declaration of protected material. The second judge...
Would that be res judicata under California law if the same people weren't parties to it?
Well, it would at least be collateral estoppel under Ash versus Swenson, because the prosecution has to be stopped from continuing to prosecute something which they must know is protected. It was the same district attorney's office.
The same defendant?
No, a different defendant, but the same material. Now, somewhere along the line, if a defendant or a person in a criminal case who is charged with a criminal offense must have the opportunity of saying, look I am protected. Isn't that what scienter means? Doesn't scienter mean that the person is doing something which he thinks is all right? Or conversely, if you want to prove that he had a mens rea of the offense, he had to know, or at least have reason to believe, that the material which he was selling or exhibiting or purveying was not protected or in the realm of hardcore pornography. But these booksellers don't know that because they get a decision from Red Rupp of protected material, and then down it comes to the lowest court, and sometimes even the highest court, and they say, we don't believe it. Nobody could hold anything like that to be protected.
Do you have any provision for an in rem proceeding in California? Proceeding against the material as such, and which would be res judicata vis-a-vis the state as against the material?
No. There is the aspects of it blowing in the wind, but it's not legislative. It would be judicial because of some recent decisions that came out of the district court, 3-judge courts in the Central District of California, stating that perhaps the search and seizure statutes which we have and the 1538.5 of the Penal Code, which allows for a traverse to a search warrant, although it doesn't meet the Friedman requirements or the Blount versus Rizzi requirements of a fast hearing provided by the state, at least one court has said that's sufficient hearing, and you can probably traverse the search warrant on the basis that the material was not in fact obscene and couldn't be seized, because that's the law in the state of California also. If it's protected, it can't be seized. But the big problem is, how do you get word to the judge that it's protected?
Well, if you did have a final judgment in that kind of a proceeding, I suppose then it would be res judicata that particular material was protected, wouldn't it?
It ought to be. But what happens is that the judge will say, as he did in the second case, first of all, these aren't exactly the same materials, so therefore they must be different. And you can argue all day long that one portrayal of an act of sexual intercourse is very much like another act of sexual intercourse.
Well, you're not talking then about precisely the same film, an absolute duplicate. You're talking just about similarities?
I'm talking about two film that if you put them back to back and took away the faces of the actors, it would be impossible to describe any difference in what was portrayed on the screen.
But films presumably at least sold under different titles or produced by different producers.
Right. Some of them may have different titles, but there just is no way. I recall the old saying, you've seen one, you've seen them both. You've seen...
An in rem determination with respect to the one would not really help you very much, would it?
Well, it's got to help somebody.
Unless it's a copy of precisely the same film, you wouldn't have it.
Well, that, I guess, is the big problem. Because if I see a magazine that shows a picture of a naked woman with her legs spread, what is known in the trade as a beaver shot, and this court has said that's protected, and I see another magazine with a woman with her legs spread and a beaver shot with a different title and a different woman, I would like to be able to tell my client it's all right to sell that because it's been held protected. But some courts will say, why, that's ridiculous. It's a different woman, and it's a different camera angle, and it's a different magazine, so how can the material be protected? One of the most beautiful cases in point, and it was handed to me by my brother, Mr. Shello, who will be arguing later, is a case of Wisconsin versus Simpson out of the Wisconsin Supreme Court, filed October 31, 1972. And in that case, they had, from what I can determine, magazines with nude persons together and nothing more. And here is some of the holdings of the Wisconsin Supreme Court. And incidentally, I had brought it along, and now I don't seem to be able to find it in the recent article, the most recent edition of the New Yorker magazine. There's a little cartoon that shows two gentlemen in black robes strolling along, And one of them is saying, if it turns me on, it's smut. So that's about what's happened with the Wisconsin Supreme Court. Here's what they say. Described magazines are not, as a matter of law, not obscene. This was the contention raised. Appellant argues that these magazines cannot be found obscene because only nudity is depicted and not sexual activity. Given non-obscenity for non-sexuality, argues appellant, these complaints are not sufficient because they do not allege obscene depictions of sexual activity. Supportive of his proposition, appellants asserts are several Redrup reversals and certain language in State versus Amato. They go down. This court, in Court versus State, resoundingly rejected the contention therein presented that this court is bound by the decisions in other courts regarding whether similar magazines are obscene or not. And he puts in quotes, the subjective nature of the material as well as the subjective conduct of the respective defendant requires an individual analysis in each case. A complete rejection by the Wisconsin Supreme Court of what this court said in Redrup, that certain material is protected. They say, we'll tell you whether or not it's protected. We'll tell you whether or not we viscerally have that feeling. Another example of the type of reaction you get from the lower courts. The question is, was the introduction of the magazines into evidence without further evidence sufficient to prove their obscenity beyond a reasonable doubt? And they say, this court has repeatedly held that obscenity is not so elusive a concept as to require expert testimony. There is nothing here that warrants any further consideration of that question, and the evidence in the form of the magazines themselves was clearly sufficient to prove obscenity beyond a reasonable doubt. You know how this case went to trial? They took the magazines and threw them into the jury and said, this is what the man is selling. And remember, these are magazines of a man and a woman in nude, and that's all they're doing. And the court is saying, we will ignore everything and we're going to go our own way. What do you do? Well,
Marx, as I recall it, correct me if I'm wrong, you urged us on a prior argument that Younger against Harris was wrong and that we should overrule it. You maintain that point
Absolutely.
now, or did I?
Absolutely. I mean, assuming that you can find some judges in the district courts, the federal district courts, that will follow the law of this court, because you don't always follow that either. I was continuing my saga of horrors, which this court is very familiar with, the case where there were 20,000 rolls of film seized in Southern California, and the district courts held they couldn't be seized, it was unlawful, and Judge Hanson of the Superior Court said, poo on you, in effect, and it went to the Court of Appeal. Judge Hanson was never held in contempt, of course, because judges are immune from that sort of thing, and it went through 3 or 4 or 5 respective courts, finally came up to this court, which affirmed the district court 3-judge ruling, and finally the films got back after 5 or 6 months of the most extraordinary waste of time, in my opinion. And getting back to the initial premise of my argument, can't we give a defendant in a pornography case the same due process of law that you give a juvenile or that you give a parolee? Can't he have a hearing, such as you said in Morrissey? Can't he have the same presumption of innocence? That is to say, in Winship, you said due process says that each element of the offense must be proved by competent evidence beyond a reasonable doubt. Well, we have 3 elements of the offense. We actually have 4. They were stated in this court in Roth. They were stated in memoirs, and it was just recently approved by this court in Rabe versus Washington, which approved Roth and memoirs as to the 3 elements. And the 3 elements are very simple. Does it go beyond contemporary standards? Does it appeal to the prurient interest? Is it utterly without socially redeeming value? Doesn't the prosecution have the burden of proving those elements, First Amendment elements, beyond a reasonable doubt under the 14th Amendment, so the defendant can have a hearing and a trial on it? And don't they have to present evidence, competent evidence? I say the due process says they do. The 4th element is even more elusive, and that's the scienter element. Smith versus California said you've got to know what you're doing. The basic element of due process of law is that you have mens rea, criminal intent. These people are businessmen. Maybe they're in a dirty business that you don't like, but nevertheless they are in business. They don't want to violate the law.
Do you understand Smith against California to stand for the proposition that the seller must know what's in the book that he sells, or alternatively, that the seller must know that what is in the book he sells is illegal?
I say that he must know what's in the book is illegal or probably illegal. Because if you just say you know what's in the book, then you get into the wildest speculation. Does that mean that he knows that there's some pictures of nude people? Does he know it's sexually oriented? The Bible is sexually oriented if you take some passages. What do you have to know about the contents of the book? I think you have to know or have some reason to believe that he knows that this has gone beyond that which is legally protected.
That goes a little further than what the opinion in the Smith case actually said, doesn't it?
Well, it goes a little bit further, but it has to be a logical and rational extension of that scienter requirement, because if you don't have that scienter requirement, you might as well overrule Smith versus California and say anybody who sells a book or shows a motion picture that deals with sex is subject to arrest and prosecution under some standards which are slightly less than the standards which are afforded to most other criminals. And I say, finally, there's an instruction that used to be given, and it still is at times. It says in the federal courts to the jury, if he's guilty, say so. If he's not guilty, say so. I say in this instance, if you're going to give us some standards and you're going to say that the First Amendment applies to the states, say so. And if you're going to tell the courts below that they can't seize material without having an adversary hearing or some sort of hearing afforded to the person, say so. And if you're going to say that they can't prosecute without having a hearing or some determination as to material, say so. But at least
I gather, Mr. Marks, what you're proposing is that there be required, before there may be a criminal prosecution, some kind of civil proceeding at which there's a definitive determination whether the material involved is or is not obscene.
Exactly.
Is that what you're talking about?
An injunctive type of proceeding.
Which would be conclusive. Well, what about how does that apply in pandering situations?
I think that if you're, first of all, I have never seen a case since Ginsburg which has that type of pandering. I think that case is out in left field and will never happen again. But if it does happen again, this court has found ways to get around what has otherwise been apparently restrictive rules of law. If the person is pandering and he knows it, the law allows for it. There's room for all those, that type of exception. Thank you.
Mr. Marks, under your theory, would it be permissible for the state to deal with a particular book or a particular movie in an in rem proceeding and, given a favorable result to them on the obscenity issue, bind anyone from thereafter who used it in the state on the issue of whether or not that was obscene?
No, I think what they must be, the only thing that they can bind the defendant on in a separate question is scienter. After that hearing, no other defendant can go about and say, I didn't know it was protected, because the law presumes that everybody else knows the law.
So even though the new defendant was not a party to that proceeding, he can't defend on the grounds that it was not obscene?
Oh, he can defend on the ground that it's not obscene, because I would say this, as long as your procedure is going along, you'd obviously have to have an in rem proceeding with the right to appeal by whoever is appealing. But the question of scienter, knowledge of as to whether it's obscene, would be withdrawn, because don't forget, in a in rem proceeding you have a judge sitting there. And the judge can rule on the
I think that the only thing a judge can rule on is whether or not the book is not obscene. If he rules that he will not make such a finding, that the book is not obscene, that it is not protected, then notice is given to the world, as it were, to the criminal defendants, that this may be the subject of a prosecution. Because he can't foreclose by saying that the book is obscene the right of a criminal defendant in a case to have a jury trial on that.
Well, then the kind of in rem proceeding you contemplate binds the state but not the defendant.
Absolutely. And that's the way it should be. Thank you.
Mr. Capizzi.
Mr. Chief Justice, and may it please the Court. With respect to the in rem proceedings, I would suggest that it is not the answer, for as Mr. Justice Brennan has suggested, it doesn't solve the question raised by the pandering concept enunciated by this Court and adopted in California by statute. Nor does it take into consideration the definition which this Court has given to obscenity, namely that to be obscene we must apply contemporary standards for customary limits of candor. And as I suggested last January when the case was argued before this Court, contemporary standards, if they are contemporary, they're going to change maybe from day to day, certainly from month to month or year to year. And we're going to have to constantly re-examine that same book to see whether or not it's obscene, applying contemporary standards, not the standard that was applied 6 months ago when the hearing was held. With respect to the knowledge that is necessary, I suggest that the only knowledge necessary is knowledge as to what is in the book. To require that the person disseminating the material must know that the material is obscene would be to totally insulate the distribution of this type of material from any sort of criminal prosecution.
Well, Mr. Capizzi, I gather your argument that because of the aspect of it must be contemporary, according to contemporary standards, that might be an argument against a particular conclusion of non-obscenity be binding on the state where the same material was involved later. But what about the argument that in any event, before there should be any criminal prosecution, there ought to be a judicial determination of obscenity or no obscenity before that proceeding continues?
Of course, I anticipate another problem that would raise, and that in a civil proceeding, the burden of proof is by preponderance, whereas in the criminal proceeding it would be by beyond a reasonable doubt. So there would be another disparity there. In effect, at the present time,
if the finding were, in the particular case involving the dissemination by a particular defendant, would it matter if the determination were that it is not obscene, applying a preponderance test?
No, well, in effect, in California, as Mr. Marks has suggested, we have what borders on that sort of procedure. It's not as a civil proceeding as such, but it's a preliminary determination of the constitutional question, the mixed question of law and fact.
Well, except as I understood Mr. Marks, at least as to some judges, they apply a probable cause test. They don't, in fact, make the ultimate determination of obscenity or non-obscenity, as I thought he told us. At least some judges.
Some judges, I feel, possibly do that. They feel that...
well, what would you feel? Well, if you're to have such a proceeding at all, do you think it should stop with a probable cause determination, or should it go on to make the ultimate determination of obscenity?
I think the initial question should be a probable cause determination if we are in fact going to have that determination. But I would suggest that that determination that's made by the trial judge is the same determination that is facing this court in each obscenity case, and that if we adopt a sufficiency of the evidence test, that initial determination doesn't necessarily have to be made. That is to say, is it protected in the constitutional sense as a matter of law, and if not, then the person is going to stand trial. But merely treat it as we would any other case, hold the trial, and then at the conclusion of the trial and review, determine whether or not there's sufficient evidence to sustain the conviction beyond a reasonable doubt and to a moral certainty.
Well, of course, I gather, so far at least, our cases have indicated that you don't approach this as sufficiency of the evidence basis. It's a constitutional determination, and we have finally to make the determination up here. That's the way we've handled it so far, haven't we?
Yes, I don't know that there's really that much difference, however, between
I think there's a considerable difference. In a negligence case, you determine sufficiency of the evidence. We don't determine negligence up here. But in obscenity cases, we do. It's a constitutional determination, don't we?
Well, that's true, but it's a matter of either it is or it isn't, rather than it is by degrees.
Well, I don't understand why, if you're going to have a civil proceeding, which is to consider the obscenity of the material for which the defendant's being prosecuted, why you shouldn't go all the way through and have a judicial determination that it is or isn't obscene, instead of just a probable cause determination.
If there is such a civil proceeding provided for by law, that may very well be what would be necessary.
I thought you said California has something like this.
Well, there's a determination that's made by the judge as to whether or not this matter is constitutionally protected. And the question of law, as I suggested, the question that this court determines every time a allegedly obscene book or obscene matter is presented to it for review.
Well, I thought Mr. Marks
it's not
suggested that the practice is different, at least as it's carried on by some judges in California.
Well, I will concede that the practice does differ among the judges, the trial judges.
Do you distinguish between a probable cause standard and a civil preponderance of the evidence standard? Are they different in California? Isn't by its very nature a probable cause or a preponderance of the evidence a balance of the probabilities? And how is that different from a probable cause test?
I'd say it's probably similar. The two...
They both fall short of the standard of beyond a reasonable doubt, don't they?
That's right. However, if in the procedure that California follows, if we required proof beyond a reasonable doubt before we could get to a jury, we would in effect be denied a jury trial. And if we proved it beyond a reasonable doubt to the judge, why is a jury trial necessary? Or if he rules, no matter how he rules, one party to the proceeding is being denied the constitutional right to a trial by jury. So I think we have to first determine whether or not this particular matter justifies going to trial. That's the procedure that's followed in California at the present time. That's the procedure that was followed in this case. Contrary to the suggestion propounded by Mr. Marks, there was a determination by the trial judge shortly after the arrest in this case, a determination that this was not constitutionally protected matter. That took place in May of 1969. Mr. Marks attempted to appeal that to the appellate department of our Superior Court, and the appellate department of the Superior Court concluded that the trial judge was correct and this was not constitutionally protected matter. And it was after that decision by the appellate department of the Orange County, California Superior Court that the decision of the L.A. Municipal Court, which is a written opinion and relied upon by Mr. Marks, was signed. So if there's a doctrine of res judicata or collateral estoppel that applies in this case, the initial decision was the judge who heard the matter in this case and concluded this was not constitutionally protected material. And the trial judge in Los Angeles County should have been bound by that determination as opposed to Orange County being bound by the later decision of the L.A. Municipal Court judge. The case was tried, evidence was produced, and the jury was instructed on the basis of a statewide standard for customary limits of candor. And it was on appeal for the first time that the appellant suggested that a nationwide standard should be adopted and applied. This was after he had produced evidence and concurred in instructions to the jury that a statewide standard should be applied.
Is that the phrase that's used in California generally in jury instructions and in court opinions, that the measure is the customary limits of candor?
Yes, the material must go substantially beyond, applying contemporary standards, it must go substantially beyond customary limits of candor.
Candor.
Yes.
Candor means honesty.
Honesty, frankness, purity.
Is that test used in other First Amendment areas in California?
Yes, as to all allegedly obscene material, that's the test that is applied to determine whether or not
beyond obscene materials in any other case involving a First Amendment claim. If it's too honest, is it illegal?
No. I think it is a term that is exclusively used for...
Seems to me rather an unfortunate phrase to use.
Well, it's a phrase that is enacted by statute following the decisions of this court.
The more honest it is, the more unlawful it is.
Well,
I think that's what the word candor means.
There are varying definitions, I believe, propounded by the dictionary. Purity is one of them. Frankness is but one definition that is used. However, simply because someone is frank or honest does not necessarily insulate that conduct or speech. And I think a similar area would be libel if it's done maliciously, even though it might be honest. Let's say truthful. Suggests that the Constitution does not require that a nationwide standard be adopted. If we're to say that the limitation of states is through the 14th Amendment and the Due Process Clause of the 14th Amendment, the implication is that the states may deprive its citizens of life, liberty, or property if due process is followed or complied with. And due process in the past has not required that each state have identical laws for depriving its citizens of liberty. The different states provide varying types of conduct as criminal, and it seems that it should be no different for each state to have a slightly different definition as to what constitutes obscenity than it is to have a slightly different definition as to what constitutes burglary or any other crime.
I don't know that anybody's made a claim that burglary is protected by the First Amendment.
No, but it involves conduct and it involves freedom of action. If each state must have an identical definition as to what constitutes obscenity, how can we avoid the conclusion that the definition of any crime must be the same from state to state? Because in obscenity, we're talking about the freedom of speech. In any other sort of criminal conduct, we're talking about freedom of action. And I'd suggest that freedom of action is likewise a very, very basic concept.
The one's in the First Amendment and the other isn't.
The other's in
nothing in the Constitution that says you have freedom to steal or commit burglary or murder or mayhem or assault and battery. But there is something that says you have the right of free expression and free speech.
No, but freedom to do what we wish, and the states prescribe certain conduct as not being permissible. Likewise, from state to state, if we're talking about the Due Process Clause of the 14th Amendment, should we not have different definitions as to what constitutes obscenity? The fact that in addition to the constitutional argument, I'd suggest that practicality suggests that a nationwide standard is simply not possible. In Denver, dancers wear pasties and G-strings. In Southern California, they wear nothing. What is the standard? Or to further illustrate it, let's assume for the sake of the illustration that east of the Mississippi, the dancers wear pasties. west of the Mississippi, they don't wear pasties. What is the national community standard for limits of candor? How are we going to average or determine something that's not subject to determination? From a practical point of view, it would be very easy for the appellant in this case to determine the standard in the various localities. Much easier than it would be for him to determine the standard on a nationwide basis. The whole is made up of the parts, and while the parts may be readily identified, simply by identifying the parts you can't necessarily arrive at a description as to what the whole is. If we were to adopt something that was acceptable to the nation as a whole, we would probably have something akin to what we see on TV, something that's acceptable for dissemination indiscriminately into any home and to anyone who might see it, which is in effect what we have in this case. It was mailed unsolicited into the home where anyone within the home might open it and see it. Thirdly, I would suggest, with relation to the earlier comments, that judges in determining obscenity matter in the constitutional sense are determining a question of law, and the local judges are not capable of determining what the national standard for limits of candor is. How are they going to determine what the limits of candor nationwide are? Experts? Experts might be fine for the trial judge, but if we have conflicting experts, how is the appellate judge to resolve the conflict? The basic principle that the trier of fact can determine credibility because he views the witness is absent when the appellate judge is looking at the whole record. Further, as attorneys and judges, it's, I think, easy for us to accept the proposition that speech acceptable in one location is not acceptable at another. We describe things one way in the office to contemporaries, partners, and associates, which description, if used in court, would probably subject us to contempt. Why? If location is not important, why can't we speak the same way in the courtroom that we can speak in the office? I think obviously that in that situation we recognize that the limits of candor, honesty, frankness, differs from place to place because we have two different communities in effect, the office and the courtroom. And the same is true from city to city, county to county.
You mean you're less candid in court than you are in the office?
Well, no, Mr. Justice Marshall, but we use different terms sometimes to describe the same thing in court than we do in chambers, in the office, or sometimes out of court. And I think the reason is not simply a question of honesty, because both descriptions are honest and frank and describe the same thing. But it's the language that's used is acceptable in one location and not acceptable in another location. The test then submitted, the states are free to adopt whichever community they choose, whether it be local, state, or national, for determining customary limits of candor. In this case, the state chose the statewide community, and it's submitted that the evidence amply established that community was, the standard for that community was exceeded. The evidence amply established that the material predominantly appealed to a prurient interest, and although Mr. Marks says he hasn't seen a case since Ginsburg that involved pandering, I would suggest that this case itself may very well involve pandering. These were brochures containing a number of scenes from the book they purported to advertise, and very little of the text of the book is there, only the most graphic depictions of sexual activity, selling predominantly the prurient appeal of the books as opposed to whatever social value they may or may not have.
Mr. Capizzi, did I understand you to say that in California you attempt to apply a state standard?
That's correct, yes.
How is that any more easily applied than a national standard?
It's not, I would concede. It's extremely difficult to establish. In adopting the statewide standard, the state court said that expert must be used to establish what that standard is or to assist the trier of fact in determining that standard.
I suppose a jury, however it's instructed, is going to apply what it regards as a standard to what a local standard is.
It's possible, although they're administered an oath and asked to follow the law, and presumably they do follow the law.
In any event, you are conceding that what might be the standard in a northern California county might not coincide with the standard in Los Angeles.
Oh, most definitely.
Well, you're going to stop with what the Supreme Court.
That's correct. That's correct. I'm suggesting that the Constitution does not make that standard impermissible, and the Constitution would likewise permit of a local standard if the law of that state indicated a local standard. In other words, the state itself is free to adopt the standard which it sees fit, and neither of the three standards, local, state, or national, violate the Constitution as applied to the states through the 14th Amendment.
Going back to Mr. Justice Blackmun's question to you about the jury acting independently, isn't the jury permitted to credit or discredit any evidence that it wants to? And
Most
particularly,
definitely.
isn't that true about expert testimony?
That's correct. Most definitely. Simply because the expert testifies doesn't mean the jury has to accept that which he relates to them if he disbelieves that witness. But responding further to the question, the statewide standard is difficult to determine or to prove or to provide experts on. Extremely difficult. A nationwide standard requiring experts to establish would be virtually impossible to do.
Has the California Supreme Court undertaken to define statewide standards of what constitutes negligence or reasonable care? Or did they leave that to juries on a case-by-case basis?
That's left to juries on a case-by-case basis, yes, Mr. Chief Justice.
Would it be fair to say that it's possible to have one type of a verdict in Northern California in a homicide case and a different type of verdict on substantially the same evidence in some other part of California?
No question about it, yes.
That's the nature of the jury system,
That's
isn't
the
it?
nature of the system, that's correct. Further, with respect to the third element that's required in California by statute, and that's the issue of utterly without redeeming social importance, I would like to emphasize the redeeming aspect of social importance and ask that that not be treated lightly or dropped from the full phrase. It seems to be glossed over on occasion or completely eliminated. But if the phrase is to have meaning, then the redeeming aspect of utterly without redeeming social importance must be emphasized. Everything, as suggested by Justice White, has some value to society, whether we learn from it, hopefully. And if that is the test, strictly social importance or social value, then nothing is going to be obscene, but it must be utterly without redeeming social importance. Would ask that court reject the necessity of determining obscenity in the constitutional sense on a piece-by-piece basis and adopt a sufficiency of the evidence test as applied in other cases. No matter which test is adopted, submitted that the material in this case is patently offensive and substantially exceeds any conceivable standard for limits of candor. And for that reason, we would submit the judgment should be affirmed. Thank you.
Thank you, Mr. Capizzi. Mr. Marks, do you have anything further? You have 2 minutes.
Very briefly, thank you, Mr. Chief Justice. I say this. I may have some disagreement as to whether probable cause hearing is different from a preponderance of the evidence hearing, and I personally feel that Chapman versus California would necessitate a beyond a reasonable doubt hearing. But that's not the point. The point is, give us a hearing and let us work it out. That's what happened before. Give us a hearing. Let the person have his chance in court, not in a criminal prosecution, which was never meant to apply to a First Amendment case.
As I understand it, though, you're not talking about giving us a hearing, in your words, with respect to the precise material involved in any particular case, but just sort of generically, with respect to material generically.
Give us a hearing which will bind the state so that they can't continue to harass and prosecute for the same type of material.
Well, the same type of material, not the same material.
No, the same type.
And that's where one...
Who's going to decide whether it's the same type?
Exactly.
Well, somebody knows it when they see it, and you can look at it, and there's just no question.
Isn't that what you're doing now? Jury by jury?
If you are doing a jury by jury, you're doing it on a proposition that one type of material has already been declared to be protected, and you can't even bring that type of evidence in some cases before a jury or before a judge to a stop.
But are you saying any more then than that in some courts before some juries a verdict might be manslaughter, that on the same evidence might be second-degree murder? Is that, I take it as a lawyer, you'd acknowledge that that does happen?
Oh, that has happened, but that isn't what I'm saying. Perhaps what I'm saying is that the defendant has to have a chance to know before he can be put before the jury and made to do something. And the state should give the opportunity, and they should be forced to produce the evidence by an impartial state, not the police officer testifying as the expert, but impartial evidence before an impartial judge. That's what we do.
Thank you, gentlemen. The case is submitted.